Frank versus Linkner. I understand that counsel for one of the parties is in a traffic problem and has not yet arrived. But
yes, Your Honor, there's a fatal accident on 96, a huge tie-up. He got caught on the wrong side of it. My name is Brian Shannon. I'm one of the counsel for appellants.
As unfortunate as that is, we are going to proceed, and you will have 15 minutes.
Why only 15 minutes, Your Honor? It's not a MOA.
I understand.
Okay.
It's unopposed at the moment.
This is, again, it's Brian Shannon for... Put my briefcase on the wrong side.
Oh, are you?
Yes, Your Honor.
Okay, then we'll proceed. In normal course.
I may be replaced by Mr. Christopher Cataldo, who is the one who's prepped to do this.
Oh, okay.
He's the one caught behind the accident. This is
Are
Mr.
you prepared to go forward or not?
I am. If you don't want to start your party now until after this case, why, I'm prepared to go.
We are prepared to move. Are you prepared to make the arguments?
Yes.
Thank you.
This is Mr. Jeffrey Morgenthau, who is counsel for two of the defendants. As I say, if Mr. Cataldo can get here, why, I will defer the rest of my time to him. This is, in our mind, primarily an accrual case. It's an oppression action. And the accrual rules don't work neatly with oppression actions, but they do work. The basic accrual principles are not at issue. Both sides cite the same cases. Court of Appeals also cited the same cases, but the Court of Appeals, at the end of its opinion, in frankly an offhand manner, made a distinction between an action for damages and an action for one of the other equitable remedies under the oppression statute. This is an LLC case, so these are members, but it works the same way for close corporations. The distinction that the Court of Appeals tried to make, that because only damages were sought, that this was a different kind of animal and wasn't, and accrual didn't occur until the Oppressive Act, which happened in 2009, until after there was a liquidation of the company, so that in 2012, when it was sold, that's when the Court of Appeals decided to start the clock ticking. That makes no sense. It makes no sense because the company might not have been sold, and it might not have been sold until 2020, 2050. It's impossible to say. What the Court of Appeals did is to postpone accrual indefinitely, and that is just unworkable, and plaintiffs concede that they had a cause of action in 2009 when the Oppressive Act occurred. The Oppressive Act is alleged, which of course we don't agree is oppressive, is that when there was a new operating agreement made and entered into, and actually signed off on by the lead plaintiff, I might add, that event caused they were trying to get some new capitalization. You'll remember perhaps times were tough then the economy was down, the company was floundering, it needed some new money, and in order to get the money, it created a new class of memberships that had a liquidation priority, a distribution priority of $68 million. They got the first part of the money. So the plaintiffs, the value of their membership interests, and only 2 of the plaintiffs actually were members. That's an issue that wasn't addressed below, would have to be addressed if the case went back. But these 2 members, they lost $68 million in equity in the value of their membership units then. Could have sued to unwind it, they could have sued for a buyout. All the remedies in the oppression statute were available to them then. So their cause of action had accrued. The clock had started ticking. And the Court of Appeals has announced a new accrual rule for oppression cases that is just completely unworkable, as it happened to happen in this case. The company was sold in 2012, and the funds were distributed exactly as provided for in the
Counsel, good morning. Help me with this, because this is something I'm really trying to kind of grasp, to really understand. So, looking at this kind of from an equitable basis, if I'm not aware that there was damage done, if I'm not aware that there was harm done, until I actually try to liquidate the stock or try to understand the value of the stock, I mean, isn't that really what the Court of Appeals is saying? I mean, help me to understand your argument that in this situation, the plaintiffs weren't necessarily aware that this had occurred or that there was damage done to them until the sale of the company, where they actually realized that now there had been damage done. I mean, help me to gather and understand that.
Wouldn't it be helpful if you anchored your argument in a text somewhere of a statute?
I can do
when
that.
When does it accrue? Where do we look to determine
you look to your own precedent for accrual rules. An action accrues when all the elements are present, regardless of damage.
Well, where did that come from? Is that a statute?
There is a statute of limitations and statute of repose in the Oppression Act.
Okay, so you think that they're one of each in this statute, not 2 statutes of limitation?
There is, according to the Bax case, which was binding on the panel below, but of course is not binding on this court.
Well, I'm really trying to get you to. I mean,
I'm trying.
Justice Bernstein has asked, why would we have a situation in which all of the elements of a claim, including damages, as a rule to determine when accrual comes? You said, no, damages is a different thing.
Well, that's what Maul says.
Okay, well, Maul didn't come out of the ether unbidden.
No,
what was it anchored at?
I think what the Court's precedent means is that you can't wait until you can determine your damages to the penny. As soon as you've been harmed, as soon as you recognize that you've been harmed, like by losing all that equity.
Wasn't Maul based on a statute, a construction of a statute? No?
It was, I believe, a personal injury case.
Wasn't there a statute involved? Statute of limitations?
The statute of limitations, right. But that doesn't teach you what accrual means.
Okay.
Do you agree that the financial harm didn't occur until 2012?
Oh, no.
You don't
no,
agree?
I don't agree, because they lost their equity in 2009. The operating agreement said the money will be dispersed this way when there's a distribution, and it gave the money first to the new units and then to pay off a bunch of notes that had been converted to units even before '09. And so in 2012, when the sale was held, all they did was follow the operating agreement, which under the statute, Your Honor, it can't be oppression.
I understand your point. I'm simply suggesting their wallets were no lighter at any earlier time. What is it that, in your judgment, specifically conduces toward the conclusion that the cause of action accrued at some earlier time?
Because all the elements of the tort were there in '09. That is the guiding principle of when accrual begins. And to answer your question, Justice Bernstein, Frank knew. Frank, the lead plaintiff, knew about these events in '09. He signed the new operating agreement. He bought Series C.
But help me to what I'm trying to grasp is, so how does he know what his damages are? Like, how
He doesn't need to know exactly. That's the point of this court's decision in Gebhardt versus O'Rourke. It says that the fact of an identifiable loss, not the finality of money damages, that triggers accrual.
So let me ask you this. Could the plaintiffs in 2009 brought an action to have the operating agreement canceled or altered under 4515(1)B or for buyout under 4515(1)D, for example? And would that have avoided or prevented the losses they suffered in 2012?
Absolutely. They could have. They concede that they could have. They're trying to bifurcate the oppression statute to make damages a separate kind of action apart from all the other equitable remedies. But this court's decision in, and I'll mangle the name, in Metagula, I think it is, the 2014 case, it's in the brief. That case just forecloses them from making that claim. It says that all the remedies, and A through E are listing the various kinds of remedies, that they can, that they're all equitable.
Arguably,
so even the damage action.
Arguably, they could still pursue those equitable remedies, correct?
To the, yes, they can. I mean, all they want is money. Companies long been sold now. Really, the only thing they're asking for
It's money.
is money. But in theory, they could have asked.
Are you familiar with MCL 600-5827?
That's the general statute of limitations.
Does it apply in this case?
It does not, because there is a specific statute of limitations in the oppression statute.
Yeah. Well, there's an explicit reference in 5827 that the claim accrues at the time the wrong upon which the claim is based is done, regardless of the time when the damage results.
Oh, right. You got me. That's what that was a quote from me, and I attributed it to Mall. But it is it's the basic principle of.
Yeah, well, so I say Mall didn't come out of ether.
No, it didn't. No,
but you just told me that this statute of limitations is inapplicable to your case.
There is a more specific statute that applies to oppression cases. I'm not saying that rule is inapplicable. That rule does apply, and the distinction that you're making is certainly not one that ever occurred to the Court of Appeals.
So is this just an ordinary tort claim? I understand that the ordinary tort claims, when all the elements are present, then the tort has been committed and the statute starts running. But if this were a breach of fiduciary duty claim, which is kind of like a shareholder oppression claim.
Well, it's almost exactly like that.
Yeah, okay. So then we would say that the claim wouldn't accrue until the injured party knew or should have known of the breach.
Well, but that applies to the parties here who were actually members of E-Prize. They knew.
Okay.
They knew. The lead plaintiff, Frank, remember,
Yeah, he
signed
knew.
on to the agreement.
But what about the others?
The other one who was a member was Atler, who was the chief financial officer. He knew. So the remainder of the plaintiffs aren't even members. They have no standing here, but that's an issue which has not been addressed by any court because since the trial court granted our motion on that it was time barred, it never got to standing, and it never got to the fact that Frank, for example, took the money for the units he bought and signed a release. There are other issues.
But it sounds like, as to the other plaintiffs, maybe you think the statute hasn't run as to them, and then we should send it back and you can litigate these other issues.
They could go back, I suppose, and we could rule on standing starting in the trial court. They have no standing. But this case is mostly about Frank. I mean, there's a whole list of plaintiffs, but this is Frank's case.
Yeah, but they were all dismissed on statute of limitations grounds, so we have to do something.
Right, and this decision needs to be fixed. Frank was a member with a notice in 2009. He knew everything in 2009, and he had every element of his cause of action then.
So, Counsel, can I ask you a question, though? Just going back to that, and I totally hear your argument, but how do we know that that's the whole idea here. How is this not a question? I mean,
it's not a question of
factual
fact.
question.
It's not because it's in the record. He signed the operating agreement.
That's what I'm just trying to really grasp, though. So he signed the operating agreement. And again, I understand the argument that he wasn't necessarily aware of the full extent of his damages because the damages come in a little bit later, and I get that. I understand that.
No,
but you understand my question, though,
I
right?
do. I think I do. The reason he knew that he was harmed, that he had an identifiable loss, was he saw the waterfall, what we call the waterfall. It's the schedule in the operating agreement of how funds will be distributed. It shows that the shares he had, except for the new shares that he bought, I call them shares, they're units. The units he bought, except for those, all the others were dropped down below $100 million in payments that had preference to his. His shares, his units were subordinated.
So, Counsel, let me give you a hypothetical, though, and this is kind of what I'm really trying to grapple with. What if it is, not in your case, but let's just say, what if there is a question of fact as to whether or not, there was a question as to they were aware of the harm when the harm took place? Then how would I address the argument of statute of limitations versus statute of repose? It's a question of fact. You're not certain. How do I establish that was the absolute date where this circumstance and situation happened?
Well, for purposes of accrual, it's first, I have to say again, it's not an absolute that he can quantify exactly his damages. It is a question of, does he know he's been harmed?
What's my bright line rule that you want me to adapt?
The bright line rule is that when all the elements, including an identifiable loss, are there, that the clock starts to tick. You know you've been harmed. You know you've been oppressed. You know that the agreement says that if there's a distribution in the future, it's going to happen this way. And because you know it's going to happen that way, you know that you're not going to ever see a penny for your units unless the company is sold for more than $100 million, and even then you've lost that value.
But so,
instead of
counsel,
getting
but would it be your contention that all of those elements have to be present for accrual to start? What if most of them are present, but you're absent one?
No, they all need to be present.
They all have to be present. And what if there's a question of fact as to whether or not all those are present? So unless all those elements are present at that moment, would you then kind of contend that accrual hasn't started at that exact moment?
I suppose there can be is there ever a triable issue on
Yes, that's what I'm getting to.
Accrual? Possibly. The court is supposed to decide the question as a matter of law, but I suppose that's not inconsistent with saying.
So if there's any vagueness, whose burden would it be at that point?
It's an affirmative defense, and so it would be the defendant's burden.
So, okay, so if there's any vagueness, then this would be an issue that would have to then be ultimately determined or litigated, correct?
Well, it would have to be a genuine issue of material fact, at least.
Okay, thank you.
You want to reserve time?
I would like to reserve time. Thank you.
Mr. Chief Justice, and may it please the Court, Gerard Mantis. I represent the plaintiffs and appellees. I'm here with my partners, Doug Turing and Fatima Mansour. There were two questions, and I do waive my uninterrupted time.
Well, then tell me how to, this statute arises under, you did it, I was going to listen, 450, 4515-1, that's the statute under which this cause of action arises?
Yes, Your Honor.
Okay. In subsection E, this is an action seeking award of damages, which this is, must be commenced within 3 years after the cause of action under this section has accrued, and then it's or discovery.
Yes, Your Honor.
Where do we look to determine what accrue means? It isn't defined here as it is in section 5827. Does 5827 apply to this case?
Yes, Your Honor. I think we look at we start with 600-5827, which requires some harm. Because if we didn't have harm to the plaintiffs and we only...
So 5827 does apply in this case?
Yes, Your Honor.
All right.
That's the general statute I think that would apply.
Then why isn't your claim untimely, since in 2009, the value of your client's stock, or interest, I should say, was subordinated to almost everything else in the world. They didn't have to know that precisely what the devaluation is, but they knew that they were last in line behind everyone else. Is it fair to say that your clients understood that once this new arrangement, financing arrangement was put in place, that they didn't know how much their interest was devalued, but they had to know it was devalued?
Your Honor, I would say 2009 is not the date when the clock starts running for 3 reasons. First of all...
Could you ask my question first? As soon as the new financing agreement is put into place and your clients are moved from wherever they were down to the bottom of the pile for any payout, did they not understand that they had suffered a devaluation of their interest?
No, Your Honor.
Okay.
For several reasons. First of all, most of the plaintiffs didn't even know about that they were allegedly being diluted.
So they were unaware of the agreement?
Yes, Your Honor. Mr. Franks signed a signature page. He did not have the operating agreement before him. The other plaintiffs never saw the operating agreement or any of these allegedly...
They were unaware of it?
They were unaware that they were being diluted.
Some sort of concealment of this?
We believe there was fraudulent concealment, and we so pled in paragraph 113 of the complaint. But second of all, Your Honor, and this is very important, that part and parcel of the oppression here was the oral agreement. The oral agreements made to every single one of my plaintiffs, and the affidavits are in the record. And the breach of the oral, and the affidavit of Jeff Dwoskin, for example, at paragraph 12 states that he was promised by defendant Linkner that, quote, I would receive a pro rata share of any sale of the company based on my membership interest, and that such shares would not be diluted. The breach of that agreement, the harm to them, and the substantial interference under 4515 did not occur until the company was sold and the agreement was breached.
So if the company wasn't sold for 500 more years, does the claim accrue in 500 years? And is there any way for us to avoid that with the rule you're proposing?
In
the facts of this case, the claim would not have accrued until the sale was...
Because of the oral agreement.
Because the oral agreement...
Whatever the reality of the new investment instrument that clearly demoted their interest. The fact that they were orally assured we won't follow that makes this a non-accruing event.
Yes, Your Honor. And also, if there were a dilution that the clients didn't know about that did not have attached to it an oral agreement, that case would be different, and we would have to look at the facts of that case. But there could be fraudulent concealment because it appears that opposing counsel is conceding this is a statute of limitations, as he must, because this is all the language of a statute of limitations. A statute of repose has very different language measured by the last act of the defendant, which we don't have here. So with a statute of limitations, we know that under 600.5855, a fraudulent concealment can toll that statute. So in the hypothetical posited by Justice McCormick, while there might be accrual in another case with different facts without an oral agreement, upon the dilution, there would be fraudulent concealment because fiduciaries have a duty to speak and advise of what's happening. But in this case, the Court of Appeals below specifically held at pages 6 and 7 that the breach of the oral agreements made to each of my clients that they would share when the company was sold, that was part and parcel of the oppression. They did not appeal that ruling. So the oral agreement is part of our cause of action under 4515, which is the member oppression statute. And furthermore, in Matagula versus Taub, 496, Mish 685, which I argued before this court 3 years ago, an oppression action under 450-1489, this court held that the breach of a shareholder agreement can be evidence of oppression. So we have the clients, the plaintiffs, each promise that when this company is sold, you will share in the proceeds. Justice McCormick, you asked whether my clients could have sued in 2009. I would answer no, under the facts of this case. In 2009, there were too many what-ifs. We know that we need harm. We don't have harm to the plaintiffs in 2009. The company might never have been sold. So
they couldn't have sued to have the operating agreement canceled or altered or for a buyout? Those were...
No, Your Honor. In 2009, there was not a penny of financial harm. It would have been totally speculative and premature.
Just a moment.
Yes, Your Honor.
So they didn't know about them, about the operating agreement?
Well, that's the first answer. They didn't know about it.
Well, all right. But if they had known, you're saying even if they had known that they would have, the claim wouldn't have accrued once they read the agreement?
I would say no, Your Honor.
Only because you couldn't quantify whether they would suffer a loss because they didn't know how much the assets would be sold for. Isn't that right?
No, Your Honor. I would say even different. I would say they wouldn't know if they would ever be harmed because if the company was never sold, there was no certainty the company would be sold.
Yeah, but they knew immediately, if they had read the thing, that they were on the bottom of the pile, whereas before this operating agreement, they were far higher in the hierarchy of payout. Isn't that a harm in and of itself?
It is not.
If the company went on for another 100 years, yes, perhaps they wouldn't suffer an actual quantifiable loss, but they have lost position, equity in this company.
And why can't they, I mean, I understand your position that they didn't know and that you could deal with in your fraudulent concealment claim later, but if they did, Why can't they just sue under 4515(1)B to have it canceled or altered when they realize that they're now at the bottom of the line?
Your Honor, under the facts of this case, their claim is rooted and deeply attached to the oral agreement. And Mr. Atler signed an affidavit that's in the record. He was one of the plaintiffs, was the financial officer for the company. He was told that there were some...
The financial officer of the company was unaware of the operating agreement?
He did not see the operating agreement, Your Honor. He knew there were other investors, and his affidavit said that Mr. Linkner asked him to perform calculations that would make sure that that would rectify and account for the fact that there were other investors, so he and the other 6 plaintiffs would not be diluted. In a closely held company, plaintiffs are made, other members are often made promises. And I think to require people to sue prematurely is not good policy.
I think you're using words in a very undisciplined way, and I'd like to connect the statute again. The issue isn't when the plaintiff suffered concrete or calculable money damages. It's rather when plaintiff first suffered harm that, and I quote 4515(2), which is the oppression statute, that substantially interfered with their interest as members. That's the standard, isn't it?
Yes, Your Honor. 4515 is very important because it requires not speculative.
It sets the standard.
Yes.
It's not the calculability of damages. It's when there's a substantial interference with their interest as members.
Yes, Your Honor. It requires a substantial harm.
On that standard.
And under that harm, under that standard, my clients did not have their interest substantially interfered with until the company was sold, because that was the payday. They were told if you work 60 hours a week for 5, sometimes 6 years, you will share in the proceeds. To say that they had to sue when, hypothetically, they knew about agreements that that other investors came in and would get a bigger equity share.
There's some disconnect. The standard is substantial interference, and you're saying, I'm just having difficulty. If they knew of this operating agreement and were given oral assurances, does that make, don't they have an obligation to make sure that those are enforceable promises at that point? I'd be very concerned if I was aware that I've now been shoved from wherever I was in my equitable interest down to the bottom, and to be told, well, we'll take care of you, unless that were someplace in the operating agreement to ensure that I was going to be taken care of.
So, Your Honor, if we take the hypothetical where my clients were given the operating agreement and saw their dilution, well, then we look to Section 4.5 of that operating agreement. It's entitled Self-Dealing, and it says, basically, no interested transaction could occur. A self-interested transaction could not occur unless it was voted on and approved by the disinterested members and the 50% of the disinterested managers. That never occurred here. So even if they had received this agreement, they could have assumed that the oral agreement would have been honored because there was never money could not have gone to the defendants without
a vote.
And that couldn't have happened. So they breached the agreement. If at the trial court level they want to rely on the operating agreement, they breached that agreement because they paid themselves $100 million, 6 of my clients $0, in a self-interested. A lot of these funding mechanisms when a company is in trouble is when new investors are brought in who are not interested. Here, they were favoring themselves. They were managers and members, and they get $100 million. My clients get $0, and they did it in a self-interested transactions that were not voted on and approved by the other members.
That doesn't tell us when their claims accrued.
Your Honor, they accrued when the oral agreement was breached in 2012. Until then, a claim would have been wholly speculative. There was not a penny of damage that my client could have proffered to the court and the claim would have been premature. If we say that the claim accrued in 2009, the policy would then be to encourage shareholders and members, when anything askance or untoward seems to be happening, that they need to rush off to court, otherwise they're going to be out of court.
Doesn't your claim then isn't it founded on fraudulent concealment? Because if there isn't fraudulent concealment, I'm having some difficulty with understanding your argument. I understand that, yeah, when they finally in 2012 or whenever it was sold the assets, you could quantify your client's loss, but they were clearly set up in this operating agreement. They had a diminution of their equitable power. You agree with that, right?
Yes.
Okay. So that's without a quantifiable situation, they did know they had suffered a diminution of their equity. So that's why I'm having difficulty with how this all works out.
Your Honor, they did not know they would ever be harmed because
that's not the standard of the statute. Substantially interferes with the interests of the members as a member. Unquestionably, a diminution of your equitable interest interferes with your interest.
Yeah, Your Honor, but even under all of these new investment vehicles that were signed, there were discretionary monies available, and that's in the record, millions of dollars that my clients were told by the defendant Linkner that this discretionary money, even apart from the waterfall to the defendants, would go to them. So there was no harm. They had no reason to expect in 2009, hypothetically speaking, if we assume they knew about the agreements, they would have had no reason to expect that the defendants would have dishonored their agreements and not used at least the discretionary money to compensate them and honor the promises they made to them. The promises are replete in their affidavits that when we sell this company, you will share in the proceeds as a shareholder. And to say that they had to...
What did the Court of Appeals say about these oral agreements? I'm having difficulty finding
at pages 6 and...
all I've found so far is in footnote 3 a reference to the fifth operating agreement containing an integration clause.
Yeah.
Is there something more favorable to your client?
Yes, Your Honor. The court said that, referring to the breach of contract claim and the agreements alleged by the plaintiffs, the court said, quote, these do not materially...
What page?
I believe that's pages 6 and 7.
6, statute of repose and statutes of limitation, or which claims?
Which claims, Paul?
He was referring to contract. My pagination of the opinion, you've got the slip opinion.
It's top of page 7. I'm sorry, it's in the slip opinion. It's the top of page 7.
What is the heading?
Shall I read it to the court?
Yeah, that'd be helpful.
Okay. Quote, here, the gravamen of plaintiffs' breach of fiduciary duty and breach of contract claims are that their interests as members were infringed when defendants obtained a huge return on investment by devaluing plaintiffs' shares in E-Prize. The essence of these claims then, which substantially mirror count 1, is the alleged breach of duties imposed by the member oppression section of the LLCA. MCL 450-4515 therefore applies. So basically saying...
I don't understand how that implicates the oral agreement.
Because the court said that the oral agreement is part and parcel of the oppression cause of action and is not a separate cause of action.
Well, I can understand how if the fiduciary is saying, don't look at this agreement or don't pay attention, I'm going to fix it for you.
Yes.
That might be a part of a violation of the Act, but I'm not sure that negates accrual.
Your Honor, I think
that might be a separate act, but the actual diminution of value of your equity seems to be pretty well fixed when they put that agreement in.
Your Honor, I would disagree. The affidavits are clear-cut that what they expected was that when the company was sold, they would share. that agreement wasn't breached until there was a sale. And the substantial
Is there anything
interference.
else in the Court of Appeals that addressed that issue?
No, Your Honor.
Let me try to put it in as simple terms as possible what's concerning me. Under 4515(1)E, the statute says that an award of damages to the limited liability company, an action seeking an award of damages must be commenced within 3 years after the cause of action under this section has accrued. It seems to me that the Court of Appeals read that section to be this subsection because it's referring to the actual damages. You want us to refer to when the damages accrued. But the cause of action under this section accrued, this section being subsection 1, and the words illegal or fraudulent or willfully unfair or oppressive conduct are actually stated what a significant action is in subsection 2. Mm-hmm. And so it seems to me the Court of Appeals, to get to focus on damages, has to read into subsection 8 this subsection as opposed to the entire Act. When the entire Act defines what is a significant action, that being substantially interferes with the interests of the member as a member, and that has occurred in 2009, how do we get past that? You know in 2009 that this action has occurred. Even with an oral agreement, there's this operating agreement out there that is sticking it to your clients.
But his position is they don't know about that, right?
You're just giving
You're correct. I don't agree with that.
they're just giving assurances that come out of the air for no particular reason.
I would say the substantial interference language in subsection 2 applies to all of the causes of action under 1A through E, and that did not occur until 2012.
Notwithstanding the language of the fifth operating agreement.
Absolutely. And I would point out that under 1A, B, C, and D of 4515, we do have 6 years under those causes of action. That's how the statute reads. That's what Estes held. That's what Irish versus natural gas holds. And Judge Zara, you were on that panel where the court said, quote, accordingly, Judge then Zara was on that panel, where Irish held, quote, accordingly, the residual 6-year limitations period in 600-5813 presumably applies to plaintiff's claim insofar as he requests equitable relief instead of damages.
But you're not seeking equitable.
We are, Your Honor.
Okay.
When this, if this is sent back to the trial court under 1A through D, we will be seeking several equitable remedies that would have a 6-year statute. And
For those.
For those.
The award of damages, those under E.
Excuse me, Your
The
Honor.
award for damages is mentioned under subsection E.
Damages would be subject to the 2-year, 3-year statute.
That's the one you're really concerned about here in this case,
And
right?
it says in there the cause of action under this section. My concern is it seems to me, it doesn't say under subsection E, but it talks about the whole section. So if there's any cause of action that arises, it has to be brought.
For damages, at least.
Within 3 years of the time the cause of action under this section has accrued.
I'm sorry, Your Honor, I'm not following the question. Are you suggesting that the 2-year, 3-year statute applies to 1A through D as well?
No.
Oh, okay. I didn't follow the
Any cause of action
question.
that's brought under 1
Yes.
has to be brought when the cause of action has accrued. Now, whether it's a 6-year, a 3-year, it accrues when any cause of action under this section accrues. I read the Court of Appeals opinion as putting into this subsection E after a cause of action under this subsection, only damages, only section E.
No, I didn't read it that way, Your Honor. I don't think that would be appropriate. I think the same accrual language.
So would there be no focus then on damages? It's when the cause of action under this section accrues, and it tells us in subsection 2 the definition of what is willfully unfair and oppressive.
Yes.
The substantial interference with interference of the member as a member.
Yes.
Doesn't that occur in 2009 with the fifth operating agreement?
Not under the facts of this case, Your Honor. When they were told you will be made whole, you will share when the company is sold, and that oral agreement was repeated to 7 different plaintiffs, that breach occurred when the company was sold and they didn't share the proceeds. That's when the cause of action accrued.
One of these plaintiffs signed that agreement, did he not?
Your Honor, there's a question of fact on that. He signed a signature page. his affidavit is that he never saw the rest of the document, and there's been no proof of that.
So why is that a question of fact? Did he sign it or didn't he?
He didn't have the operating agreement, Your Honor. That's his position.
Okay.
And Your Honor, even for Mr. Franks, they still ignored the rest of his shares. So that he was damaged and harmed the way everyone else was. He was given the same promise that when the company was sold, all of your other shares will be compensated. He walked away with zero for those shares, 950,000 shares.
Okay. If, counsel, if your clients are signatories to the 5th operating agreement, and it has an integration clause, like the Court of Appeals judges indicated in the footnote, why should we, and the Court of Appeals judges found that the gravamen of the breach of the breach of contract claim is an impression claim. Would you then agree? I mean, we're talking about all these issues that are really not before the court. If there's fraudulent concealment, and if they didn't sign and they didn't see it, and if somebody put a document and they signed it, but it was, the rest of the document wasn't there. I mean, that's not really we're not here to find facts, right? We're here assuming that the 5th operating agreement was signed by the parties to it. And am I right that you're here arguing for an oral modification, even though there's an integration clause, or am I missing? What am I missing?
At least for Frank, right?
Yeah, at least for Frank. I mean, if these other people didn't sign and they didn't see it, and somehow they have rights under it, even though they didn't sign it, or they signed the earlier one but not this one, those are all a host of all different issues than the very narrow accrual issue that I think we're here to talk about.
For Mr. Frank, Your Honor, first of all, the defendants materially breached that agreement because they engaged in self-dealing, paid themselves $100 million without a vote, and therefore they can't enforce it.
But he can't modify that agreement with an oral agreement.
Your Honor, they can't enforce it under common law principles when they materially breached it. That would be our first argument. Second of all,
but you rely on the oral assurance as a way around the accrual. As to Frank, that can't work since he signed the agreement, whether he read it or not, and it contains an integration clause negating reliance on oral agreements, correct?
no, Your Honor.
Okay.
If the other signatory party materially breaches that agreement, they can't enforce it. Many cases say that. So
they can't enforce which agreement, the written one or the latest?
The joint operating agreement, because they agreed that they would not pay them, so they would not engage in self-interested transactions.
He may have a breach of contract on the operating agreement, but he can't possibly rely on the oral agreement with the integration clause, correct?
I would disagree for two reasons.
So if I sign an agreement saying, Bob, you can't rely on anything else, oral or otherwise, that isn't the four corners of this agreement, and the agreement is breached, I get to rely on the oral agreement?
Your Honor, the integration clause relates to any agreements relating to this agreement.
Yeah.
I would hold that because there was discretionary money available, even apart from whatever the defendants were going to pay themselves, that they could have complied with both and without breaching either. So he would still be able to bring his claims, and I would still maintain that, Your Honor, because the defendants materially breached this agreement. They can't enforce it against anybody, even against Mr. Frank.
Can I just understand the state of play real quickly? If this Court disagrees with you on both the accrual date and the characterization of the statutes of limitations and statutes of repose issue, do we still need to remand, in your view, for consideration of the fraudulent concealment argument in full and for consideration of whether either of the statutes of limitations in 4515E apply only to your request for money damages and not also to other claims that you have before the Court?
I would say the issue of the statute of limitations for causes of actions under 1A through D is still an issue, irrespective of the Court's ruling, because I believe that would be a 6-year statute of limitations. Fraudulent concealment would still be an issue if you hold this is a statute of limitations.
It would be an issue as to both of the statutes of limitations or only the 3-year statute of limitations?
As to both, Your Honor.
Okay. Okay, so you think we would still have to ensure that those are taken care of by the lower courts, is that right?
The issues of the accrual of the other subsections and fraudulent concealment.
Non-monetary damages.
Yes. Yes, Your Honor, because one of the equitable claims here will be for disgorgement, and that would be a 6-year statute of limitations. And that's what Irish held, that's what Estes holds. In Estes, the court said, quote, as a result of the 2001 amendments, Section 489 contains an express limitations period for damages claims under a cause of action under that section. So we would still have 6 years, even from 2009, and we filed in 2013. But back to accrual, members of the court, there were plenty of proceeds to go around in 2012 had the defendants acted fairly and equitably. And we know from Matagula versus Taub that 450, 4515, and 1489 are equitable statutes. Nothing of what they did here was equitable, sending the clients walking with zero when they were promised they would share. When they sold the company in 2012 and breached their agreements, that's when the clock started ticking, and that's when the cause of action accrued.
Thank you.
Thank you.
Can you address this oral argument? It really is very...
Oral agreement.
I'm sorry, oral...
It was going to be my first point.
There isn't much in the Court of Appeals opinion that clued us in that this is a factor negating an accrual here.
This is a published oppression case that purports to explain when oppression actions accrue. There's virtually no mention, well, there may be a passing reference, but the case wasn't decided in any way on an issue regarding an alleged oral
It seemed to
agreement.
It seemed to, at least in my consciousness in my review, that didn't come up as a strong issue. So
Right. It was a position that can be, the claims can be found in the complaint. There's the affidavits that Brother Counsel mentioned.
Okay,
but
I understand, but now it's here, and
now it's here. This is what we have to deal with is a mistaken opinion published on the issue of accrual and oppression actions. And I might mention also, because there's some concern about what Mr. Frank knew or didn't know, that he not only signed the operating agreement, but he signed a subscription agreement as well at the time. He saw the waterfall at the time.
But there's some others.
I'll move past that. There was also some discussion of a few controlling members slipped this through. The new operating agreement was signed by 99.5% of the members of E-Prize.
Okay. The question is, I guess at one level, they're claiming they didn't know anything about it, other than Frank. Okay. Now,
some of the non-members may not have known. I have no way of knowing.
Okay. Is there a material question of fact on who knew what when?
Well, it's not material if they're not members. It would be my short answer. If they're not members,
what about
I bet
Mr.
you
Franks
folks
who
didn't
says,
know.
I signed this piece of paper, but I didn't get it. I didn't read it. They told me it was a permission slip for my kid or whatever.
It's possible there may be a few residual little things that the trial court could address on remand.
Do we have to just remand and say, figure this out? Because
well,
the statute,
please don't just remand.
Well, that's what I'm wondering. If it is true that there's a question about when people knew, is when people knew relevant to the question? And I thought when you were up here before, you said yes, because we should analogize this to breach of fiduciary duty claims, which clock starts ticking when you know or should have known.
I don't think I quite said that. The action starts to accrue when you're harmed, the notice issues don't have anything to do with accrual, and I didn't mean to imply that if I did.
Why not? Why don't they have anything to do with accrual?
That has to do with it does have to do with accrual in the sense
Counsel,
that if
how do
you,
I take action if I don't know?
yeah,
that
let me correct myself. You're right. You have to know that the elements are there, and so to that extent, knowledge is relevant.
Yeah.
But Frank knew. He signed multiple things. He saw the waterfall.
But you're asking us to decide that he knew as a matter of law, and I just asked you whether there's a question of material fact about whether he knew. If there is, then what?
Well,
what do you want us to do? What would you like us to do?
So what I'm trying to say is that if you can send a question back to the trial court about notice, as long as you correct the mistake that the Court of Appeals made first, that they weren't damaged until 2012. They were damaged in 2009, and there's really nothing
Counsel,
much
what
left.
if the court holds that? What if the court holds differently? What if the court holds that they didn't have knowledge in 2000? I mean, how do I write an opinion that says
You can't hold that as to Frank.
Is this, the rule you want is that the statute of limitations is applicable here concerning accrual accrues when they knew that their status, there's a statutory phrase, that their interests were harmed, in effect. Isn't that it?
Yes, when they
Whatever the dollar harm is, it is irrelevant as long as they knew they had suffered a harm as members.
and if they knew or should have known about the waterfall that was part of the operating agreement.
But that's part of what they had to know. They had to know of the waterfall is the harm. That's what diminished their equitable interest, right?
Yes.
Okay, so the rule is accrual occurs when they know, let's say, or should have known it, but when their interest as members have been harmed, right?
Right. Right. And
Irrespective of how much harm.
And in this case, it is clear that if they knew what was done in 2009, that then their action accrued.
Action substantially interferes with their interests as members.
Right.
So if the waterfall agreement, the operating agreement, substantially interfered with their interest and they knew it, they're not how much they would lose, but they have lost their equity. That would have been sufficient to cause their actions to accrue.
If the only issue that goes back is what they're chargeable with knowing, then, and of course for the non-members, the standing issue, that's not before you, then I'll be content.
It all relates to when the cause of action under this section has accrued, not when the damages occur, right?
Well, there has to be an identifiable harm, I think, for it to have accrued, but I read the court as understanding that being dumped to the bottom of the pile is an identifiable harm. So that
I think a cause of action includes damages. So you don't mean if there were damages identifiable in 2009, like being put to the bottom of the list, there were damages they could have sued for in 2009, even if they couldn't identify the specific money damages that would result from the sale. Is that, am I helping? Okay.
Yes.
Or hurting? I don't know.
Yes,
and any oral representation that don't worry about this doesn't change that fact, does it?
I don't think
because at that point you're still a cause of action is accruing for
right.
misrepresentation.
Right. That's right.
And while there is a discovery
Everything
provision, the
accrued in
statute
09.
still says 3 years or 2 years within discovery, whichever occurs first.
And I might note that the court specifically said at the beginning of its opinion that all of the claims that were before the Court of Appeals arose under the oppression statute and would be bound by its decision on the time bar on oppression.
Thank you.
Thank you.